So that is all I had. I wasn't sure on our timing on this, but I guess now we do have time for a few questions if you want to go ahead. I know Eileen is there waiting, so I'll stop sharing.
Thanks, Ken. Um, I have a question on the slide that talked about some of the new standards. I know in the past when standards have gone up, the department has said, you could use the new standards. You're basically, if I recall, you're basically using them as a method two, to use them in the interim. But with the change in the potential for imminent hazard numbers, is that something that can be used in the interim, or they really don't go into effect until March? And then I guess part B is, I'm assuming with the increase in standards, there were also some changes in reportable concentrations. I haven't looked at those. But same question, if some of the RCs have gone up, do we need to hold out until March, or is there kind of a little bit of a workaround for both of those categories?
So in terms of the standards and making use of them now, we do have the ability to publish under method. There's a provision in method 2 to publish a list of standards, and we have done that in the past, and we do intend to do that. I think we will shortly have the list of standards. Or we could also do it by reference to the draft that we have on. So we don't necessarily need to produce that list, but I think we will. And so once we have a statement out there, and shortly, I mean, most likely the next couple of weeks, that you can use those and apply those to current sites. I'm trying to think. I think reportable concentrations we've always handled differently because we wait for those to go into effect. In the past, we might have dealt with those in the effective date provisions in a different way, but I don't believe that ability we have under method 2 extends to reportable concentrations. So I don't know if we'd have that language in terms of the regulation itself to kind of back that up. And I'm going to allow Paul to clarify anything if he's hearing this differently. We have had corresponding changes to reportable concentrations. I didn't mention that, but yes, they have changed as well. They all changed as proposed. And there was one more thing you had. One more question
about the changes in the potential for an imminent hazard. Some of those have gone up even pretty substantially.
Yeah. So in practice, we have actually been, when we get notifications of those, I think we have been recognizing those changes. So it in kind of approvals when the regions take those notifications. So I think between now and then, we would continue on with that practice. So for example, if someone is notifying of something based on the current could pose number, and the proposed, the number to go into effect in March is higher, that will get addressed at the time of the notification.
Okay, so it's likely, it sounds like the right approach is to still call in and notify, but the need for an IRA may not be necessary. Exactly. Because the department will account for that, but at least it's all been documented.
That's right.
Okay. All right. Thank you.
Paul, did you want to follow up on anything I said?
No, only that that draft list that still needs to be QA'd is now in your email box.
Oh, so there you go. Deborah? I don't know if I'm taking the hands in turn, but yeah. Deborah Darby.
I had a question concerning moving 21E soils from one site to another. and I understand that you are putting together guidance for that. Does this guidance cover situations where I'm moving liability from one owner to another owner? Or would this also include where I'm retaining the liability, but I'm just swapping the soil from one site to another?
That's an issue that's yet to be determined. But yes, that's one of the legal issues that's where we're trying to resolve. And it might be an agreement between the source and the receiving person. We don't know. But I don't have a good answer to that yet. But that is definitely a question that needs to be answered.
Yeah, and I think our lawyers would be happy if we point out that a lot of the liability issues are dealt with in the statute, and it's, DEP can work with policy and regulation, but there's limitations on kind of how we can address statutory liability,
Correct.
and that's why it's complicated.
Yeah, because there is no statute for 21E sites. They're only for quarries. So yeah, it gets complicated.
Right, but I guess the question then, I understand if I'm transferring liability to another entity that doesn't have that liability, but in my view, it's not the same if I am moving materials where I have the liability to another location where I also am responsible for that liability. So will you be making that distinctions when you do your policy or
Yeah,
not?
that needs to be addressed. Absolutely. The whole question of liability definitely needs to be flushed out and addressed and clarified. Absolutely.
Thanks, Deborah. I'm not sure who's next. Kate?
Thank you, Liz. Ken, I'm thrilled to hear that the department's working on that COM 23 policy. Thank you for that update. I'm interested, I acknowledge the complexities that I'm sure you're working through as you develop that. It's interesting that it is called COM 23. Wondering if you have any comments on anticipated timeline.
Can I just throw in that the MCP was called 2019? So.
Thank you, Liz. That's not hopeful.
No, I have no better information on the timeline for the COM 20, what we're calling, quote, COM 23. It'll probably be COM 24 by the time it's done. I mean, as you saw on that slide, there's lots of other things on our plates right now. I know this is a big one, but this one is still very much in the developmental phase, just beginning. So, and there's a lot of things that need to be resolved, but we'll be talking to you guys a lot, especially you guys in the coalition. I'm sure we'll be talking to you guys more about this over the next 3 months.
And is it correct to assume that the ongoing development of that policy doesn't inhibit proposals to be made in the meantime? You did mention that there's one that you're working through already.
Correct. There's more than one. There's a handful. There's probably half a dozen right now that have come in.
Great.
Some of them are 21E to 21E. Some of them are more COM 15 kind of things that are not necessarily quarries. But yeah, there's a handful of things that are out there that are being looked at right already. And it has to follow, in the absence of a policy or a statute, it has to follow an ACO with the soil management plan. So yes.
Thank you.
Thanks, Kate. Lisa?
Thanks, Liz. Nice presentation. So 2 quick questions. One is on APEM requirements and the AUL. So a lot of, especially now with the PFAS standards and private well impacts, poets are becoming increasingly common. But what I've observed at some sites is that sometimes the influent concentration to the poet becomes lower than the drinking water standard and does not pose a risk, because sometimes, actually a lot of times, those poets were put in because of a CEP requirement versus, a risk-based or imminent hazard requirement. So I just wanted to get your opinion on, if you have a poet but now, and you have sufficient data, sufficient number of rounds to have characterized the influent concentration, and it remains below the drinking water standard and does not pose a significant risk. Am I correct in the interpretation that therefore an AUL is not needed in that case? They can certainly keep it running, but because it's not necessary to achieve no significant risk, it's not a required component.
I think that's right. I'll reserve my right to reverse myself, but I think that is analogous to how we've been handling it with respect to vapor intrusion, for example.
Like capping the system in a passive mode, and if it's still okay, then you
Yeah. So if those APIM provisions are written, the APIM is being used to support a temporary solution, remedy operation status, or a permanent solution. So I guess it would come down to, is it required to support the permanent solution? And I think that's how we would look at that.
Okay, that's what I thought as well, but I understand if you want reserve.
That's a provisional response.
Okay, and then my second quick question is, would DEP consider for the risk guidance, maybe having some comments, or putting it out for some review and comment by practitioners, because that's always been the case for the risk guidance, vapor intrusion guidance, and the AUL guidance that Ken mentioned. So you think that will happen?
Yes. Yes, we will have a comment period on those.
Okay. Thanks.
Jane.
Unmute. Hi, Liz. Can you hear me now?
Yes, we can.
Okay, my mouse battery picked the absolute worst time to die. Let's see. So my two questions. The first one was about the judgmental versus systematic, and just I feel like the systematic. I mean, does that really end up being like fill sites in practice? I'm just trying to think, like, it seems like a lot of sites would have some combination of the two, and so I feel like it's sort of there's a lot of interpretation there, and I'm not really sure how that works. Like, are we, we're going to interpret it, and then you're maybe going to tell us, no, that's not how we should do it, or how, like, if there's more that you could say about that.
Well, I can say that is something that in terms of training that I've been seeing being put together, it is addressed. That will address in more detail. And both I like a basic response is that both can apply to a site, and that there is room for judgment in how you approach that. Paul, can you say anything clarifying on this topic?
Well, I think so. Hopefully. There's a lot of guidance being developed on this. That's a large part of the subpart I guidance ORS is working on. It does recognize that it's not a site-wide thing. It will be addressed kind of exposure point by exposure point. It's very likely that you'll have combinations of, over here, we knew there was an underground storage tank, there was a tank bowl, there was a source. We used judgmental sampling to find out where that contaminant is starting from the source and moving out to find that. But we also want the permanent solution to apply to the rest of this property. We have no idea what happened over there, so that would be more systematic sampling to define that. And there are certainly situations where you might start out doing systematic sampling and then find sources, and then you'd be doing some
Exactly.
judgmental sampling with that.
Okay, that helps. The second question I had was on the 40.1013, because you did talk about 40.1012, and I noticed that in 40.1013 there was a change where my interpretation, it seems to be that the department's, I think perhaps requiring that, like, those non-AUL conditions, if you have an AUL, like, you wouldn't do both. So if you're going to have an AUL and you want to say no, non-commercial gardening requires BMPs, that should go in an AUL. And so, like, we wouldn't have kind of like mixing and matching of AUL versus non-AUL conditions in the same permanent solution. Is that correct? Like, I thought I saw that. I didn't hear a presentation, so I just wanted to ask about it because I thought that was kind of a change.
I don't think we intended a change there, more of a clarification, but to be honest with you, I don't have full recall on what that change was. So I will take another look at that, and if that's something we should be highlighting, we'll make sure we do. But I think that was mostly related to clarifying. And I think there's probably, I vaguely recall that there's a connection to how that also gets summarized in the permanent solution statement, because you can have a combination of permanent solutions with conditions, some of them which are related to an activity and use limitation, and then there's that list of others that are not. So I'm sorry, I can't.
Okay.
I don't really recall what's there.
Okay.
Thanks, Jane. I think we have time for one more question. I see Joe has his hand up.
Hi, thanks, Liz.
Hey, Joe.
My question has to do with active remediation systems such as an SSDS. You said that monitoring for pressure rather than shut down and restart, and it's not going to be retroactive. You mentioned that. So does that mean that once the new regs come into effect, any existing systems, whether or not they're under a temporary or permanent solution, or one hasn't reached that yet, don't need to have the pressure monitoring, but all new systems that begin once or come after the new regs come into effect do?
It means that all the sites that have permanent solutions now, there's no requirement for them to go back and begin to monitor pressure. A new system that's registered tomorrow would be monitoring pressure. And those systems in place now that are supporting a temporary solution or remedy operation status and aren't monitoring for pressure, they can continue, but should they get converted into supporting a permanent solution, at that point they would need to be monitoring for pressure.
Okay, thank you.
Okay. Well, thanks everyone. I hope this was useful. I know it was general, high level, but I felt like it was a good place to start in terms of just reminding people what was in there and give an overview. We'll obviously be having more updates of this sort over the next 5.5 months or so, in addition to more detailed training where we can deal with some of your specific questions. And as I said, please send them along. They will help us inform the guidance and the training in trying to answer them. And I think that's it. Any, Ken or Paul, any other wrap-up comments?
Yeah, sounds good.
We'll see everybody tonight.
Okay, so thank you all for joining us.
Thank you, Liz.
Thanks,
See you
Liz.
soon. Take care.
Hi, everybody.